Hello, today I'm going to be discussing the Equal Employment Opportunity Policy Brief, for short the EEO. On the agenda today, firstly, I'm going to discuss the overview of the policy. Next, I'm going to be talking about the BARDAC policy analysis and the 7 steps associated with it. And then lastly, I'll be giving a concluding statement. To start, the EEO originated in the 60s and 70s. During this time period, the Civil Rights Act was enacted in 1964, and when this act became law, not too long later, Title VII was added to this act, and Title VII specifically focused on equal employment opportunity. What that meant that was no matter color, race, ethnicity, age, religion, all employment opportunities had to be equal and fair to everyone. And these employment opportunities covered pre-employment, which is with hiring, post-employment, firing, and also employees while they're employed in terms of receiving benefits and raises and promotions. To oversee this, the EEOC was created, which is the Equal Employment Opportunity Commission, and they made sure all employers and companies followed the EEO laws. The problem with this law, the main problem is the court's jurisdiction. In the BARDAC policy analysis, the first step is defining the problem, and the court's jurisdiction was an issue because one, judges had full interpretation of the law, and this meant some judges having different interpretations of the law than other judges, which resulted in some employees and employers getting unfair rulings. In addition to that, the judges could also decide if the credibility of the plaintiff was good enough or not good enough to go on to trial, and this is also up to the judge's discretion. In addition to that, because of their jurisdiction, there was a lot of scheduling issues. The reason being is these courts have so many criminal cases and other civil cases that the EEO cases were being pushed back from 6 months to a year to even 2 years, which resulted in some employees and employers just giving up on the whole process. Some evidence to back this up. There was one case where there was discrimination allegations. A male at a company made because he was wearing earrings, and the company told him that he could not wear earrings. However, female employees were allowed to wear earrings. The male employee thought this was gender discrimination. However, when it went to court, the judge ruled that this was not in violation of Title VII. Again, it seemed like gender discrimination, but due to the judge's interpretation of the law, he threw out the case. Another issue was a disability case disregarded by EEOC due to anticipated court ruling. There was a disability case where a person felt that they were being discriminated against, but because the EEOC did not feel like there was enough evidence and they knew how the courts would rule based on their evidence and technicalities, they decided not to take the case. Another piece of evidence is a reasonable belief and its effect on cases, and this is where judges make the determination if employers reasonably knew that they were discriminating against employees. And a lot of times a judge can just make this decision based on his own opinion. And then lastly, many employees give up after too much wait time. There's so much backlog in the court system and wait time that sometimes people just forget about the cases and stop fighting. Some alternatives to using the federal court system is one, using a third-party arbitrator. This arbitrator has no affiliation with the court, also has no affiliation with the employee or employer, and they can sit down and come to a fair agreement with both sides. Secondly, the next alternative is the increase in EEOC staffing. Currently today, there's a huge reduction in staffing in the EEOC, which means lack of resources and lack of manpower. This increase in EEO staffing could really go a long way to help supporting employees who are making claims. The last alternatives is employers reporting to EEOC about employment changes. This means consistent communication, mandated reporting about anything having to do with employment, whether it's hiring, firing, raises, bonuses, etc. And this is to put a policy in which consistently and constantly watches employers and how they deal with the employees. The criteria about this and how this fits in with all the alternatives is the criteria evaluation will be done using equity, implementability, political legitimacy, and effectiveness. Equity means fairness, and in this case, equality for all. There needs to be ethical, equal treatment towards any employee, no matter what they look like or their personal beliefs are. This means there should be no discrimination during the hiring process or the employed process. Because of this, changes need to be made to the EEO and the EEOC and the court system to make sure civil rights are protected. The next criteria looks at how feasible it is to implement. When changing or adding to policy, it is important to think about sustainability. It should not be an arduous, convoluted system to manage. Looking at the worker experience, qualifications, and interviewing skills instead of ethnicity, religious beliefs, and color is not a difficult thing to do. Criteria 3 focuses on the law being passed. When a bill is passed, there should be aspects to it that appease everyone, but the policy process involved can result in many bills not being passed. A bill must be agreed to by both chambers in the same form before it can be presented to the president. When taking a look at the proposed ideas, one should be able to foresee the likelihood of this law coming to fruition. There would be no reason for a policy change that enforces EEO for everyone to be looked at negatively. And the last criteria, which has to do with effectiveness, upon examining alternative policy, a determination should be made to how successful it is or will be. Modifications to the EEO and EEOC most likely will bring about a diverse workforce. Some of the projected outcomes for all three alternatives, you have positive and negative outcomes. For the first alternative, the third-party arbitration outcomes, there's a lack of legalities because it's not in the court system. There's not so many evidence and rules in terms of gathering evidence, and the arbitrator's experience with Title VII, whether they have it or not, could be a huge outcome that can impact both sides. The second alternative, which focuses on increase in EEOC staffing, an outcome would be more manpower. Also, another outcome, which would be the same as before, is that the federal court still has power in ruling, and it's up to the judge's interpretation. The third outcome, dealing with alternative 3, which is regular reporting to the EEOC by companies and employers, definitely better business and maybe even personal relationships will be made. And also consistent monitoring of the company will be made as well. The trade-offs that these alternatives have are, for one, with arbitration, it's getting the right arbitrator. Yes, it seems like a fair procedure, and it is fair having an arbitrator, but then you also need an arbitrator that's knowledgeable about Title VII and has knowledge about the laws. If you get one that does not know, it could be unfair to either the employee or the employer. The trade-off with increase in EEO staffing is, yes, there will be more manpower for the employees, but courts are still involved in the decision and the judges still have the final say. The third trade-off for alternative 3, which is consistent communication and mandated reporting of companies to the EEOC, the outcome would be there's no control on output of information, meaning employers can still say what they want to the EEOC. They can report what they want. They can report the information they want. So this kind of leaves the employee out of the loop. And so there would still need to be some type of protocol where the EEOC is communicating with the employee and the employer to make sure everything matches up factually. After looking at all three alternatives, I believe alternative 3 is the best one, which is constant communication with the EEOC and companies. Sometimes communication can catch issues before civil hearing. And what I mean by that is constant communication, talking amongst one another, can solve problems before they even get to a civil hearing or one party wanting to have a civil hearing. Benefits of communication in this case are that the employer might make honest mistakes that kind of violate the EEO, but they don't know it does, and they can be updated on that. And then also, if it is done on purpose, it can be caught and nipped in the bud. In addition, with this communication, the employee feels more safe at work because they know their rights are always being checked up on, and there's a governing party that's watching the company and how the company deals with raises, promotions, hiring, firing, and benefits. This alternative works in the interest of both parties. It's a fair alternative, and it works for the equality of both parties. To conclude, equal employment opportunity is fair treatment in employment, promotion, training, and other personal actions without regard to race, color, religion, sex, age, national origin, and physical or mental disability. Currently, the court systems are still involved with this process of EEO today, and policy needs to be changed because the judge's interpretation of the law is just too powerful and has too much an effect on the decisions being made. To reiterate, alternative 3 is the best choice, which is mandated consistent communication between the EEOC and companies. And this allows companies to follow the laws as well as employees to feel comfortable. Today, EEO is still being debated, trying to figure out the best way to be fair to employees and employers. The goal is equality. Once this is known as the goal, in the future there should be no problem figure out a median to where employers and employees are treated fairly and everybody has a great understanding of the EEO laws. Thank you.